Good morning. I'm just going to wait about a minute more before we get started to make sure we have everyone in from the waiting room.
Good morning, Ms. Quincy.
Yeah,
Good morning. Nice to see you again. All right, it looks to me like we have everyone in from the waiting room. So I'm going to go ahead and get started today. Excuse me while I adjust my camera. There we go. Good morning. I'm Hearing Officer Nicole Kinsey with the Administrative Hearings Office of the State Water Resources Control Board. This is a pre-hearing conference in Phase 1A on the applications of North Kern Water Storage District and City of Shafter, application 31673, City of Bakersfield, application 31674, Buena Vista Water Storage District, application 31675, Kern Water Bank Authority, application 31676, Kern County Water Agency, application 31677, and Rosedale Rio Bravo Water Storage District, application 31819, all for permits to appropriate water from the Kern River system. This pre-hearing conference is being held in accordance with the notice of pre-hearing conference dated August 30th, 2021. This pre-hearing conference is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and the video are being recorded, and we will post files of this recording along with the Zoom generated transcript to the AHO FTP site. The YouTube recording will also be available on the AHO YouTube webpage. If at any time you're experiencing technical difficulties today trying to communicate with us, please send an email to admin@waterboards.ca.gov. The AHO staff are monitoring that email inbox and they can let me know. Assisting me today are several staff of the Administrative Hearings Office. We have Nicole Mullen, Amy Blunk, Skylar Anderson, and Kyle Wooldridge. I'd like to go ahead and move to appearances. To do that, I'm going to identify each of the entities that filed NOIs for Phase 1A of this hearing. And as I do, if you will please, if you're representing that entity, please unmute your microphone and state your name. So let's go ahead and get started. We'll start with the City of Bakersfield.
Yes, good morning. This is Colin Pierce from Dwayne Morris, appearing on behalf of City of Bakersfield. Also with me is Julianne Ansley.
Good morning, Mr. Pierce, and good morning, Ms. Ansley. City of Shafter.
Good morning. This is Wendy Wang appearing on behalf of City of Shafter.
Thank you. Good morning, Ms. Wang. North Kern Water Storage District.
Good morning. This is Scott Cuny from the law offices of Young Wooldridge, appearing on behalf of North Kern Water Storage District.
Good morning, Mr. Cuny. Buena Vista Water Storage District.
Good morning, Ms. Kinsey. This is Ryan Becerra of Barkowitz, Cronic, and Shanahan for Buena Vista Water Storage District. Isaac St. Lawrence is also appearing on behalf of the district today.
Thank you. Good morning, Mr. Becerra, and good morning, Mr. St. Lawrence. Rosedale Rio Bravo Water Storage District.
Good morning, Jennifer Spalletta Law, appearing on behalf of Rosedale Rio Bravo Water Storage District.
Good morning, Ms. Spalletta. Kern Delta Water District.
Good morning, Ms. Kinsey. Robert Donlan on behalf of Kern Delta with Ellison Schneider. With me this morning is Richard Iger, Kern Delta's General Counsel, and Craig Carnes in my office.
Good morning, Mr. Donlan, and good morning to your accompanying parties. Thank you. Thank you for being here. Kern County Water Agency.
Good morning. This is Nick Jacobs with Somax, Simmons, and Dunn, representing the Kern County Water Agency.
Thank you. Good morning, Mr. Jacobs. The public interest groups, and I'll list the ones that I have here, and you can correct me if I'm wrong. Bring Back the Kern, Kern River Parkway Foundation, Kern Audubon Society, Kern Cahuilla Sierra Club, Panorama Vista Preserve, Center for Biological Diversity, and Cal Trout.
Good morning, Officer Kinsey. This is Adam Keats appearing on behalf of all of those parties except for Caltrout.
Except for Caltrout. Okay. Thank you and good morning, Mr. Keats.
Good morning.
And on that note, I will ask, is anyone here representing Caltrout today?
I will note, Officer Kinsey, that our pre-hearing conference statement, I believe, was submitted jointly with Caltrout, and I apologize if we got our signals crossed. I don't believe that I'm authorized to appear on their behalf, but it's possible that got confused in the
Okay.
our joint. But anyway.
Thank you for noting that for the record. I'll move on to Tulare Lake Basin Water Storage District.
Good morning, Ms. Kinsey. Peter Keel appearing for Tulare Lake Basin Water Storage District.
Good morning, Mr. Keel.
Good morning.
And then I will ask, there are some other parties who may not be participating today or in phase 1A, but I will go through my list of other parties. Do I have anyone from California Department of Fish and Wildlife?
Good morning, Ms. Kinsey. This is Nancy Murray appearing for California Department of Fish and Wildlife.
Good morning, Ms. Murray. And is it your intent to participate in phase 1A? Did you file an NOI or I missed it? Or just, will you please clarify the intent?
No, we did not file an NOI for phase 1A. We're monitoring this and we intend to participate in phase 1B, but we want to know through this pre-hearing conference how 1A and 1B are going to be laid out.
Sure thing. Thank you very much. Thanks for that clarification. And then do I have anyone from the Kern Water Bank Authority? Is there anyone else who intends to participate today who has not yet identified themselves? All right, thank you. I received pre-hearing conference statements from North Kern Water Storage District and City of Shafter and the City of Bakersfield. And then I think, Mr. Keats, did you say that the public interest groups also submitted a pre-hearing conference statement?
No, I'm sorry. I was referring to the opening brief on the issues, the 1A issues.
Sure, thank you very much. I just wanted to clarify, make sure I didn't miss it. So thank you. So I have read those pre-hearing conference statements. I appreciate that. What I have on my list for the agenda today are a number of things. First of all, I wanted to address the NOI and request to participate as a party by Tulare Lake Basin Water Storage District. Next, I'd like to talk about the deadlines, in particular, the deadline for case in chief exhibits. I'll ruin the punchline and say I'm just thinking about extending that just by a few days, so we can talk about that. I also want to talk about whether it makes sense to, I think it does, set a deadline for amended NOIs based on the procedural ruling that you have not yet seen, but which will be coming out shortly. Third on my list are setting some deadlines for evidentiary motions. Fourth, I'd like to talk about time limits for direct testimony. Fifth, I think there are a few miscellaneous items that have been raised. One about staff exhibits. I think another question about witness testimony on pleading paper. I just thought we'd go through. They're good questions. We'll go through those and address those. And then finally, any other issues that any of the parties would like to raise today. So that is what I have on my agenda. First, moving to the notice of intent from Tulare Lake Basin Water Storage District. I received that notice of intent and the accompanying statement of interest in participating in phase 1A of this proceeding. The NOI was filed timely for phase 1A, and I think Tulare Lake Basin Water Storage District identified its interest in this proceedings, which makes sense to me. So I'm going to grant, I will call them TLB WSD party status for purposes of the phase 1A hearing. And I just wanted to ask Mr. Keel, first of all, welcome to the fun. I'm glad you could join us. And then you may not know the answer, but at this time, do you think it's your intent to be named as a party in later phases of this proceeding as well, in addition to phase 1A?
First, thank you, Ms. Kinsey. I appreciate granting this request for phase 1A. I do believe TLB will seek party status for phase 1B and potentially latter phases.
Good, thank you. I think what you will see is, if I remember to do it properly in later notices, TLB, WSD, as I said, I think you've identified a pretty clear interest in these proceedings. I will likely identify you as a party within the hearing notice itself, along with the other parties that are listed there. But if I don't, please bring that to my attention.
Appreciate that.
Moving on to the case in chief deadline. First of all, I know you all are waiting for that procedural ruling. And I apologize, it's not out yet. It will be out shortly, no later than early next week, basically as soon as possible. What I'd like to do is postpone the deadline for case in chief exhibits by just a few days. I was looking at November 8th. I don't think that would affect any of our other deadlines, but it would just give a little more time for all of you to read the ruling. And if there are any changes, I don't think it would be, the broad scope of phase 1A, but if there are any changes or narrowing or evidence that you think is not appropriate to submit in phase 1A, you would have a chance to make those changes before the deadline for submitting exhibits. As I mentioned, all of the other deadlines would stay the same. Are there any comments on moving the case in chief exhibit deadline until, I think it currently is set for November 4th. I was just going to move it until the Monday, I believe that's a Monday, November 8th. Let me check, make sure I'm saying this correctly. Yes, Monday, November 8th. Are there any comments on that change?
This is Scott Cuny. Not knowing the scope of the hearing, we see no objection to moving it to the Monday. It seems we're prepared for the 4th, so I don't know that it affects us. Not knowing the scope, though, is probably significant.
Well, it's not going to be larger. I think the primary issue, what I can tell you is this ruling will address the extent to which public trust issues are going to be addressed in phase 1A. And I would like to wait until that ruling is released in its final form for you to review that. Of course, if you have any questions after that, or you think there's another problem with the deadline as it's set, once you've seen the ruling, you're of course welcome to submit something to my office and we can address that. So that's what I would propose, is we leave it there.
Right.
And I understand you reserve your, but having not seen the ruling, all of you reserve the opportunity to raise any concerns that you may have once you've seen that ruling.
Yes, hearing Officer Kunze, this is Colin Pierce for City of Bakersfield. We have no objection to the continuance, but I would just ask if you could move it 1 or 2 days more, either to Wednesday the 10th or Tuesday the 9th, just so we have another day or two that's not the weekend, so we don't have to deal with all these issues over the weekend, if you don't mind.
That is fine with me, as long as we keep those other deadlines in place. Are there any concerns about moving the deadline to, let's say, November 10th at noon?
This again is Scott Cuny. The only issue that I can see, because I agree keeping all of the other dates, we do have some suggestions as to relating to evidentiary objections that we were, so that will make that schedule more compact, but perhaps not undoable. I just don't know yet. But I'm not troubled by the Tuesday, but I don't think it can go further than that. Otherwise, we're going to run out of time on some of these other necessary steps.
And I think, just to clarify, I think we were talking about now Wednesday, November 10th at noon. But I understand, and we are going to, the next thing on my list is to talk about evidentiary motions and deadlines for those. So let's tentatively set this for November 10th at noon, and then we will get to the discussion about evidentiary motions. And if anything changes, we can look back to this.
Thank you.
Thank you. I also wanted to, I think I mentioned, impose a deadline for amended NOIs. This is mostly to help my office so that I can have a sense of what witnesses you're intending to call, and just in a clear statement. So it's really a courtesy for me, which I appreciate. So what I'd like to do is set the same deadline, November 10th at noon, if you would please, with your exhibits. If there are any changes to your NOI in your witnesses or time estimates for their testimony, if you would please submit an amended NOI, that would be very helpful to me. Are there any comments on that before we move to talking about deadlines for evidentiary motions? So I think, Mr. Cuny, as you helpfully included, I think in your pre-hearing conference statement, you propose that we set deadlines for written evidentiary motions. I think this is a good idea, and it has worked well in other hearing proceedings. I do want to say on the substance of the motions, because I'm living and learning as I work through other proceedings, and this one, what I'd like to do is require, or what I am going to do is require that motions to exclude case in chief testimony. So just the testimony and just case in chief, but any motions to exclude case in chief testimony, I would want those to be made in writing in advance. It's very helpful. It's what I've found is it's difficult to come into a hearing and then have to deal with a motion to exclude all or portions of testimony when those can be dealt with in advance. Any other kind of evidentiary motion, you may make that in writing in advance, which is helpful to me because it's in writing, or you can make those orally during the hearing. I realize sometimes those objections come up as you're reviewing the testimony and preparing, and that's fine. You can bring those up orally during the hearing. I'm just talking about the case in chief testimony and motions to exclude that. Those need to be made in writing in advance. So we have a new deadline for submission of case in chief exhibits, which is now, we're talking about is November 10th at noon. I was looking at, it would be just less than 2 weeks now since we have November 10th, but written evidentiary motions being due on November 22nd. I'm sorry to say that's Thanksgiving week, but at least it's before Thanksgiving. And then I was looking at responsive briefs due on December 3rd. Which unfortunately is less time than it seems because of the Thanksgiving holiday, but it does give me time to address the motions before the hearing starts. And then I'm not going to allow reply briefs on the evidentiary motions. I think the motion and the opposition, that's sufficient. That's plenty. So on that timing, Mr. Cuny, I will look to you and all of the other parties. Do you have any concerns or suggestions if we have the case in chief exhibits due November 10th, written evidentiary motions due November 22nd, and then responsive briefs on those motions due December 3rd?
We can work with that schedule, Ms. Kinsey. We'll be able to accommodate that schedule.
Thank you. Good. Are there comments from any other parties on that?
Yeah, this is Colin Pierce again for City of Bakersfield. We have no objection to the deadlines, but I do want to clarify what the order will entail. You're saying that for any objection to written testimony, that has to be in writing ahead of time through these deadlines. Is that correct?
Yeah, what I had said was motions to exclude. I'm trying to think about whether there are other types of objections, but it would be an exclusion. So yes, I agree with your characterization.
Okay, yeah, I'm just, I mean,
yes.
Yeah, because I guess, you know, if there's any, I would say that, I guess the question really is if there's any objection at all to testimony, you're saying that has to be in writing ahead of time, but you're saying for other things like exhibits, that's more optional. We can still raise oral objections, for example, at the time of the hearing.
Correct. Yes.
Okay, thank you.
The reason for doing this, and maybe I will modify my practice going forward, and we can talk about this for later phases. By thinking here, one, it's just so useful to have the written motions with respect to testimony in advance. On written exhibits, I don't know how many written, I shouldn't say written exhibits, on other types of exhibits, depending on the number of exhibits. I just don't want to put all of you in a bind to have to make those objections in writing in advance. I do want to hold this hearing on the schedule we've set it for. So I just wanted to give all of you a little more time, but if we come to consensus and we want all of those objections in writing in advance, that's certainly fine with me.
This is Scott Cuny again. Originally, you talked about case in chief exhibits and we had, or evidence, let's call it.
Yes.
Identified. I assume you would not oppose written objections to both the testimony and maybe there's a correlated exhibit that goes with that testimony that to be objected to in writing, but you are indicating that as to exhibits, if that has to be done orally, that would be permissible. Is that what I'm hearing as a
Correct. Yes.
distinction?
Yes.
We'll do our best to do everything in writing, but I appreciate the concession. That's helpful.
Yes. Okay. Mr. Pierce, do you have any further comments on this? And then Mr.
No, I
Jacobs,
would just echo, I think, again, Colin Pierce for City of Bakersfield. I guess I would agree with Mr. Cooney that we will try to do all of our objections in writing to exhibits as well. But we also may have there may be instances where we object at the time of the hearing as well.
yes, and that would be fine. Mr. Jacobs.
How do you want to handle objections to rebuttal testimony and evidence?
Well, that's the next question. Yes. We'll get through. Well, let's pause on that. Are there any other comments on the case in chief element of this? And then we'll get to rebuttal. You're ahead of me, Mr. Jacobs, which is not surprising. Okay. For rebuttal evidence, the evidence is due December 2nd. What I was thinking I would do is that I would accept written motions. Well, first of all, that all objections to rebuttal evidence could be made either in writing or orally during the hearing. There just isn't time, in my opinion, to put everyone in under the requirement of making those motions in writing. I will accept motions in writing. I was thinking through December 7th at noon. So I have a chance to read them before the hearing. Because it is rebuttal, what I was thinking is I'd accept responses submitted by December 9th at noon. I realize this is after the hearing starts, but I don't think we'll get to rebuttal in the morning of December 9th. I think that's fair to say. So that was my thought on this. And again, that the motions with respect to rebuttal evidence would not be required to be made in writing. They may be made orally during the hearing, but you would have the option to put those in writing in advance. Are there any, Mr. Cooney, I see you're not on mute, but do you have any,
Yes.
do you have any comments on that?
My comment is similar to before. We'll do our best to do things in writing, but as you've indicated, the schedule is so compact at that point that some just may not be possible, and they'll be addressed orally as necessary.
And Mr. Jacobs, you raised the issue. Do you have any comments on this?
That sounds great. Thank you.
Okay. Thank you. Mr. Pierce, I'll look to you since you were in on our conversation.
The schedule sounds fine to us, and we'll do the same as Mr. Cooney said. We'll try to submit our objections in writing.
Okay, good. Thank you. Are there any other comments on these deadlines for evidentiary motions before we move on? Next on my list, I just briefly wanted to talk about time limits for testimony and cross. I think it's maybe a little premature to talk about this because I haven't issued the procedural ruling, which may affect things. But I did review the NOIs and the estimates for testimony. I did want to take this opportunity to remind you that oral direct testimony is to be a summary of written testimony that you submit to the AHO. So I did note that at least one witness, the estimate was 2 hours, which I'm a little concerned if it takes 2 hours to summarize your testimony, how long the written testimony is going to be. That said, I realize there may be some very technically complex testimony, but I'm just going to put that out there. I will assure you that I will read the written testimony before the hearing. So I will have read the testimony, all of it. It may not be entirely at the tip of my tongue because I will have read all of the written testimony, but I will have seen it before. So your witnesses really only need to give a summary. And what's really important to me, I think, and that's quite helpful, is the process of course, cross-examination and the opportunity for me and my staff to ask questions of the witnesses, if we have any. I also wanted to note it's often helpful if the witness has a short PowerPoint presentation to highlight certain elements of their testimony that they think is particularly important. But if you are going to do that, please submit those slides with the deadline for submitting exhibits, for submitting case in chief exhibits. So at this point, what I'm inclined to do is say, well, and what I am going to do, unless one of you convinces me otherwise, I'm going to limit summaries of testimony by each party to 2.5 hours. I think that's plenty. So please streamline your process if you have more than that. And even if you don't, I would encourage you to streamline those summaries. I don't think I'm going to set limits for rebuttal testimony at this time because we don't know what we're not there yet. If it becomes necessary to set time limits for rebuttal testimony, I can do that later. One of you could raise it in writing before the hearing. We can decide later whether we think we need another pre-hearing conference, or we can just do that on the fly during the hearing. In the past, I haven't set limits for rebuttal testimony, and it's worked fine. Things are sort of naturally narrowed down by the time we get to rebuttal, but we'll just have to see how that goes. We can revisit the issue if there's extensive rebuttal testimony that's submitted. So with that, limiting direct testimony for case in chief witnesses for each party to no more than 2.5 hours. Are there any comments that any of you would like to make? All right, last on my list, I have 2 minor issues that I think the city of Bakersfield raised, which I appreciate. First of all,
Excuse me, Ms. Kunze, I don't know if you addressed cross-examination time limits. Is there a?
I didn't.
Okay.
I'm not going to set limits for cross at this time. Usually cross has worked. If on the fly, we're not going down, and thank you for bringing that to my attention. I failed to mention that. If the line of questioning on cross is not productive, then I will move things along. But in the past, I think I'm not going to set a strict limit. Just as long as that line of questioning is productive and helpful to me, then we'll move things forward. Does that make sense?
Makes sense to me. Thank you. Thank you very much.
Are there any other issues before I too quickly move along? I'll give you a moment to breathe.
I also have a couple of just administrative issues, and maybe we can do them now, but they're just that administrative kind of issues.
Administrative issues. Great. Let me address the 2 raised by Bakersfield, and then I will look to you, Mr. Cooney.
Very good.
So first of all, I think there was the question of whether or not if you're submitting witness testimony on pleading paper, whether it's necessary to number the paragraphs. And I think pleading paper is fine with me. I don't have a strong preference. What's important is that we're able to identify specific lines and paragraphs of testimony, which you can do on pleading paper. So I think we'll go with that. Pleading paper is fine. You may number your paragraphs however you see fit. Secondly, I think there was this question about staff exhibits, which is a very good one because I'm still refining my process. And I think, unfortunately, I might be doing it different in every proceeding before me, but I'm getting there. And what I'm going to do is ask my team to prepare a spreadsheet of the administrative record documents that are on the FTP site for this proceeding. I took a quick look at those. I think nearly all of them would be helpful to have identified as AHO exhibits. Excluding the one, there's a folder in the FTP administrative record folder that's titled Kern River FAS hearing. I'm not sure all of those documents need to be staff exhibits, so I wasn't going to include those in the exhibit index. But if there are any documents in there that you would like to have included in the in the evidentiary record for this proceeding, please include those within your own exhibit list that you submit as case in chief. But I will have this index prepared by my staff and circulated shortly within the next few days so that you will know which exhibits we are planning to move into evidence for this proceeding. And if you have any objections to any of those exhibits being brought into evidence, you can raise those during the hearing. So during the hearing, we will engage in a formal process where those AHO staff exhibits will be moved into evidence. You'll have a chance before they're moved into evidence to raise any objections that you may have, and we can work through those. But I will make sure that we have that index out so that you know which documents the AHO are planning to move into evidence. And if there are any other documents that you think should be moved in, you can include those in your own case in chief exhibit list. Are there any comments on that issue of staff exhibits? Then with that, Mr. Cooney, I think it is your turn if you have a couple of items to raise.
Yeah. And again, both of these are administrative. One, I think, is really a point of information for both the hearing officer. We have, of course, the court reporter is here transcribing today, and she was able to help us in the prior conference. We, through our office, had facilitated that, and we were happy to do that. And we ended up in, the traditional kind of cost sharing kind of process. Separately, the court reporter was also working through her normal process. And I think my understanding is that the court reporter will prepare the transcript and then divide that work, that cost, that expense, just across the parties that are appearing in the proceeding. So there's a certain number of parties that are appearing here today, and then it would be administered and divided that way, as compared to us trying to, as it were, sort of be the administrator on behalf of the court reporter. So this is mostly a point of information, and I don't know whether the hearing officer has any questions, what the court reporter does, but that's my understanding of how process would go forward.
And maybe this is a helpful discussion. I'll just add that our office is not, this would be a process. I appreciate having the court reporter here. I certainly appreciate if those transcripts, especially from the hearing, can be made available to the AHO. There are many benefits to that, obviously, because then you can cite in your brief to the reporter transcript, which is extremely, or I should say, significantly better than the Zoom transcript or watching the videos. That said, our office isn't involved in facilitating the cost sharing and will not be participating in those agreements, nor can we require, I'm not going to require that you submit those transcripts to our office, because I realize you have to work out the details of cost sharing and
right.
the court reporter being paid appropriately, which right. I appreciate. And those transcripts, once they're submitted to us, they become part of our public administrative record. So there is that element. If they are submitted to us, we will end up posting them on the FTP site. They will be publicly available. So that's a matter of cost sharing that I would look to the parties to work out. Although, once again, if those transcripts can be made available to the AHO, it is extremely helpful in any proceeding, because then we can cite to them. So that's my addition to this discussion, that I appreciate the parties having a court reporter, but it's not something that's required, and nor would we be involved in the cost sharing process.
Well, I think those additional comments are very helpful. And so, I don't think there's an action item for us to take here this morning, but just want to advise everyone of the process and the communications we've had with the court reporter in that regard.
Thank you. I appreciate that. And if at any time we can assist in terms of sharing the court reporter's information or contact information, we of course can do that, and we would post that information on the FTP site in our administrative record. So to the extent we can help that way, I am happy to do that.
So my last item is truly just an administrative one. We have an instance in which one of our anticipated exhibits is a large amount of data that, if produced on paper, ends up to be a sizable stack. I haven't measured it, but I know it's significant. And what I'm wondering, whether or not there is not some, whether it be a link or some other kind of digital manner in which that could be, as it were, filed with the hearing officer in advance on the same schedule, as compared to turning it to paper and, as it were, a PDF. So we're just dealing with that mechanic, and I didn't know what, and I hate to burden the hearing officer with it, but I wasn't sure what to do with it.
No, this is a good, thank you, Mr. Cooney, because it actually raises another issue, which maybe I should have included in our discussion today. One is, I think, just the general issue of oversized documents, the submittal of oversized documents. I don't recall off the top of my head whether they're addressed in the hearing notice. I don't think they are, because this is we're refining our process. So what I'd like to say is, first of all, for oversized documents, and this may not get exactly to your question, Mr. Cooney, I'll return to this question of, data files and that kind of thing. But oversized documents, which I would call anything over about 150 pages, those do not need to be submitted in hard copy. You may, particularly if you think they're particularly important and that I should have them in hard copy in front of me. but I will say oversized documents over 150 pages, it's optional whether or not to file the 2 hard copies with the AHO. You may submit those oversized documents solely through the FTP site by uploading those documents to your FTP site. And then we will move those over and make them available to everyone on the outward facing download FTP site. On the question of data files, which aren't easily converted to PDF, I would say the same principle will apply. Those don't need to be reproduced in hard copy. They may be submitted to the AHO, whether in Excel format, or I'm told from my technical staff that CSV format is fine also. Those can be uploaded to the FTP site, to your exhibit upload FTP folder, and then we will make them available in the general FTP download folder for this proceeding. Mr. Cooney, does that address, as far as you know, as far as us non-technical experts go, does that address your concern?
Well, I have to confess I'm a non-technical expert. So is there I think what I would need to do is maybe have one of our staff people be able to talk to AHO staff, technical staff, as to the mechanics. Is that, but I'm also mindful of the ex parte rules, and I want to make sure that we're fully compliant in that regard. So
what I will say, if there are procedural questions about how to do the upload and whether or not we are able to read certain files, that is a conversation that I'm comfortable having your technical folks talk to my technical folks to make sure we can do that. I suspect once you talk to your folks and they make that upload, I think it'll be fine, and we can certainly let you know if we have any trouble with the file, or we aren't able to read the file. I think it's worked in the past. We've had Excel files uploaded. Again, I don't know what kind of data file this is, but we've done this with Excel files and it worked just fine. So
that answers my question. That's very good. Thank you very much.
Thank you. So I'm going to turn in a moment to see if there are any other procedural issues that any party would like to raise, but I am going to memorialize everything we talked about today in writing. I'll just pair it with the procedural ruling that you're all waiting for. So that will all come out together. So we will have in writing everything we discussed. If I miss anything and I just omitted it, please let me know. I will follow up with an amendment to the ruling that adds anything that I may have missed. I've been writing notes, but I occasionally miss things. Are there any other procedural issues that any party would like to raise today in preparing for phase 1A? I will add, I know we're all waiting for a framework for phase 1B. I'm working on that. We will move forward on that. I have a few other things to take care of, but that is not off the table, and we may very well have a discussion, or at least start the process for phase 1B before we're complete with phase 1A. I don't see them having to move necessarily consecutively, but I'm not going to jam you up with deadlines over the Thanksgiving holiday or anything like that. So, are there any other issues that you've thought of while I've been talking? Well, I thank you all for joining me. I think this was a very efficient conference. I look forward to our upcoming hearing. As I said, you will see that procedural ruling from me soon. And if you have any concerns or other issues that come up, please bring them to my attention. At this point, I don't think we need to set another pre-hearing conference unless there are other issues that come up in the interim where we need to do that, and we certainly can do that. But is there anyone who has a strong argument in favor of setting another pre-hearing conference rather than going directly through to our hearing starting December 9th? All right, then with that, I thank you all for being here. This pre-hearing conference is adjourned, and I will see you on December 9th, if not sooner. Thank you very much.
All right, thank you.
Very good. Thank you very much.
Thank you.
Thank you.
Thank you.
Thank you.